judgment in the name of John Doyle Constructions Limited and EROS Constructions Limited.
I hand down judgment in this case, neutral citation number 2021 EWCA Civ 1452. For the reasons given in that judgment, we dismiss the appeal.
The appeal in Eastern Pyramid Group Corporation and Spire House in RTM Limited Company Limited.
Yes.
Please, Your Lordships, I appear for the appellant landlord in this case. My learned friends, Mr. Rayleigh QC and Miss Muir, appear for the respondent RTM company. The appeal relates to the respondent's claim to acquire the right to manage of premises known as Spire House in Lancaster Gate. The sole ground of appeal concerns an issue as to the proper construction of Section 86 of the 2002 Act, namely whether a notice of withdrawal is effective if it is not given to the qualifying tenants as required by Section 86(2). The respondent has sought to raise two issues in their respondent's notice, and you may have seen the direction from Lord Justice Nugee that whether or not this court hears those issues is to be determined by this court.
Well, we thought that if it would be convenient, we'll hear you both on the appeal, including your reply on the appeal, and we'll then take stock as to whether we need to hear from Mr. Rainey on the response notice.
I'm grateful for that, my lord. Can I first take your lordship through the relevant statutory provisions, which are at tab 1 of the authorities bundle. Starting with section 72, which sets out the premises to which chapter 1 of part 2 of the Act apply. There's no issue in respect of that on this appeal, and so I won't go through that in detail. Section 73 and 74 concern the RTM company and the membership and regulations of the RTM company, and that's the first step in a claim to acquire the right to manage. An RTM company must be formed with the prescribed articles of association. The next step is the service of a notice of participation pursuant to section 78 of the Act. And you can see there in subsection 1, the company must give a notice to each person who at the time the notice is given is a qualifying tenant but has neither agreed to become or is not in fact a member of the RTM company. The notice must be in a form prescribed by regulations, and it must state whether a copy of the articles of association are provided with the notice or include a statement as to when they can be inspected. Subparagraph 5 deals with the provisions as to when the articles may be inspected. Section 79 deals with the notice of claim. Subsection 1 provides that the claim is made by giving notice, and the relevant date is when the claim is made. Subsection 2 provides that a claim notice must not be given until each person required to be given a notice of invitation to participate has been given such notice at least 14 days before. Subsection 3 deals with the qualifying criteria as to the membership of the RTM company. Subsection 4 deals with the position where there are only 2 qualifying tenants, both must be members. Subsection 5 is relevant in this case. that provides that the membership of the RTM company on the date when the notice is given must include not less than half the number of qualifying tenants. Subsection 6 provides the persons to whom the notice must be given. A is the landlord. B is a party to a lease. A party to a lease other than the landlord or the tenant. The most common example would be a management company who had management obligations to manage the premises. C is a tribunal appointed manager under the 87 Act. Subsection 7 deals with the position where none of the persons in subsection 6 can be found, and there is a separate provision, section 85, that deals with that situation, not something we're concerned with in this case. Section 80 deals with the contents of the claim notice, as the heading suggests. The claim must comply with the requirements set out in subsections 2 to 9. Subsection 2 provides that the notice must specify the premises and contain a statement of the grounds on which it is claimed that the premises apply, or the chapter applies to the premises. Subsection 3 is of critical importance on the issue of the validity if we get to it. It requires the notice to state the full name of each person who is both the qualifying tenant of a flat and a member of the RTM company, and the address of his flat. Subsection 4 provides that the notice must include particulars of any such person's lease. 5 provides that the name and registered office of the RTM company must be given. Subsection 6 requires the notice to specify a date by which the counter notice must be given. It can't be earlier than 1 month after giving of the notice. Subsection 7 requires a date to be specified on which the RTM company intends to acquire the right to manage, and that can't be less than 3 months before the giving of the notice. And subsections 8 and 9 require the notice to comply with any regulations.
Mr. Upton, just one part that I haven't yet understood of what you've been taking us to. Could you go back to 79.2?
My lord, yes.
Can you just talk us through what that means?
Yes, so if one goes back to section 78, section 78 is the requirement to give, for the RTM company to give the qualifying tenants who are not members of the RTM company at that point a notice inviting them to join the company. And 79.2 provides that you can't serve your claim notice on the landlord until at least 14 days
so
after
the notice of invitation to participate is the section 78 process.
That's right.
I understand.
Yes.
Thank you.
I was moving on to section 81, which is at page 5 of tab 1. This section contains supplementary provisions about the claim notice. Subsection 1 provides that a claim notice is not invalidated by any inaccuracy in any of the particulars required by section 80. Subsection 2 saves the claim notice from invalidity where it specifies a qualifying tenant and as a member of the company who is not in fact a qualifying tenant on the date the name is given. So for example, where a qualifying tenant sells the flat after the claim notice has been given. Subsection 3 is 3 and 4 are key to the ground of appeal. Subsection 3 provides where any premises have been specified in a claim notice, no subsequent claim notice which specifies those premises or any premises containing those premises may be given so long as the earlier claim notice continues in force. And subsection 4 provides that a claim notice continues in force from the relevant date, the date when it's given, until the right to manage is acquired, unless it has been withdrawn or deemed withdrawn or otherwise ceases to have effect by reason of...
So what do you say the statutory purpose of 81.3 might be?
It would be to prevent multiple claims being made at the same time, to prevent...
To prevent simultaneous processes going on?
Yes, so that the landlord only has to deal with one claim at any one time. Section 84 is the provision regarding counter notices. Subsection 1 provides that where any person is given a claim notice, then they may give a counter notice not later than the date specified for so doing in the claim notice. Subsection 2 provides that a counter notice must either admit that the RTM company was entitled to acquire the right to manage on the date the claim notice was given, or B, allege that by any reason, or by reason of a specified provision in this chapter, the RTM company was not so entitled. So that the reason may be procedural, or it may be substantive, in that the qualifying criteria are not satisfied, or it may be both. Where no counter notice is given, then the right to manage company acquires the right to manage on the date specified in the notice. That's at page 11, my lord. That's section 90, subsections 2 and 3. So when no counter notice is given, the right to manage is acquired by operation of law on the date specified in the claim notice. If we go back to section 84 on page 6, subsection 3 provides that where a counter notice has been given, alleging that the company is not entitled to acquire the right to manage, then the RTM company must make an application to the tribunal to determine that issue. And subsection 4 provides that that application must be made within 2 months of the date on which the counter notice was given.
Mr. Upson, you said must make an application. I know it says may. I think the point you're making is if they want it resolved, they must make it. If they don't make it, they won't get it.
That's absolutely right, my lord. That's because there's a deemed withdrawal if they don't. So I will take your lordship to that. But yes, your lordship's quite correct. Subsection 5 provides that where a counter notice is given denying or disputing the right, then the company does not acquire the right to manage unless it's been finally determined that they did have that right, or unless the person or persons who gave the counter notice subsequently agree in writing that they can acquire the right. And finally determined is defined in subsections 7 and 8 as effectively when an appeal is exhausted. Subsection 6 provides that the notice ceases to have effect when it is finally determined that the company did not have the right to manage. So again, when all appeals are exhausted and it is held that the company did not have the right to manage, the right to acquire the right to manage. Subsection 86 is on page 8. That is the key provision on this appeal. Subsection 1 provides that a claim notice may be withdrawn at any time. And subsection 2 provides as to makes provision as to the persons to whom such a notice must be given. And you can see A is the landlord, B is the party to such a lease, such as a management company, C is a tribunal appointed manager, and D is the qualifying tenants. Section 87 is the deemed withdrawal provision that I referred to a moment ago. That subsection 1 provides that if no application is made to the tribunal when the RTM company has been given a counter notice which does not admit the claim, the claim is withdrawn. No application is made within 2 months. Section 88 deals with the cost consequences in general. Subsection 1 provides that the RTM company is liable for the reasonable costs of those parties mentioned in A to C. Subsection 3 provides that the RTM company is not liable for any costs in any proceedings unless the tribunal dismisses the application. So in other words, the RTM company only becomes liable for the cost of any proceedings if their application is unsuccessful. Section 89 is a further provision about costs. That provides that this section applies where a claim notice is withdrawn or deemed to be withdrawn or ceases to have effect. And subsection 2 provides that the liability of the RTM company under section 88 is up until the date or up until that time. So in this case, when we're considering a notice of withdrawal, it would be up until the date of the withdrawal of the claim.
Go back to 86.2. What is your submission about the statutory purpose of that provision?
The statutory purpose of the statutory purpose of 86.1 is clearly to allow a claim to be withdrawn, and the purpose of subsection 2 is to notify all those persons specified that the claim has been withdrawn. So getting to the heart of it, my lord, one of the central reasons of the Upper Tribunal was that the purpose of the notice of withdrawal was simply to inform the landlord, and that it wasn't to inform the qualifying tenants. That was for information only.
So your submission is that a notice of withdrawal will not have effect unless it is given to each of those persons.
That's correct, my lord, yes.
So let's suppose there are 12 tenants, and by administrative error the RTM company serves the landlord in 11 of them. What's the situation there?
Well, that would be a strict failure to comply, and the question would be whether that failure to comply on the facts of that case rendered the notice of withdrawal invalid, and the answer to that would be by applying the principles in Elim Court and Nass and Osman, which no doubt we'll come on to. But the starting position would be it's a failure to comply. The notice of withdrawal is not effective, unless there was, as I say, there was an argument that it didn't make a difference to the statutory scheme that one qualifying tenant was not served. This case is quite different because I say, first of all, there was compliance. The qualifying tenants were served, and this is not a case for applying the principles in Elim Court. You simply follow the statutory scheme, and the result is that the notice of withdrawal did not take effect until the date on which the qualifying tenants were served, and because the second claim notice was given the day before, it was premature. The first claim notice was continuing in force and is therefore of no effect. So this is not a case of failure to comply at all.
Thank you.
So in summary, my lord, the notice of withdrawal has two consequences. It means that the claim notice no longer continues in force. A fresh claim notice can be served immediately, and it also has consequences as to the costs that both the RTM company and the members of the RTM company would be liable to pay. I don't think I took your lordships actually to section 89.3. I just wanted to take you to that. That provides that each person who is a member of the RTM company is also liable for those costs, joint and severally with the RTM company. That's all I intended to say about the statutory scheme. I then wanted to take the lordships very quickly through the notices. The facts are very straightforward in this case, happily. I'm in the supplementary bundle, if I could ask your lordships to find that, please. The first claim notice is at page 41, behind tab 1. That notice is dated the 18th of March 2019. You can see that at the bottom of page 43. And it's been assumed that it was given the following day on the 19th of March, but nothing turns on that. A counter notice was served in respect of that first claim notice. That counter notice is at page 48. It's dated the 29th of April 2019. And you can see that the reasons by which it is alleged that the RTM company was not entitled to acquire the right to manage on the relevant date are section 78.1, That's a failure to give the notice of invitation to participate. Section 79(2), that was the provision my Lord Justice Jackson asked about. In other words, that the claim notice can't be given within 14 days after the service of a notice of invitation to participate on the qualifying tenants. And then section 79(5) is the membership criteria. That in this case, where there are more than 2 qualifying tenants, not less than 50% must be members of the company on the date the claim notice is given. So those are the 3 reasons at that stage why the landlord disputed the respondent's entitlement. The respondent then served the second claim notice, which is at page 111. That notice is dated the 17th of June. You can see that at the bottom of page 113. And it's served under cover of a letter dated the 17th of June. That's at page 110, my first class post. And so...
Sorry, the date on the bottom of 113 is...
17.
Yeah.
Yeah.
So that's a 7.
That's a 7, my lord. Yes.
Yeah.
So it's served. It's served under cover of a letter of the 17th, and so everyone's assumed that it was given on the 18th, which is the relevant date. And while we're here, looking at the letter on page 110, it has been held that that letter is a notice of withdrawal. There were arguments about that in the courts below, but there's no appeal on that issue. And so the appeal proceeds on the basis that a notice of withdrawal was given to the landlord on the 18th. The landlord then served its second counter notice. That's at page 170.
Just remind me why a notice dated the 17th is considered to be an 18th of June relevant date.
Because it was served by first class post, so it was received the following.
It's deemed to be received the following day.
So it's given on the 18th.
Okay. Thank you. Sorry, you were taking us to the counter notice, which is at
page 170, my lord.
Thank you.
So this is dated the 24th of July. The reasons given for not admitting the claim include the same reasons that were given in the first counter notice, but also section 81(3), and that's the provision about no subsequent claim notice being given while there is already a claim notice which is continuing in force. I should have taken your lordships to the letter under which the second claim notice was served. That's at page 129. this is the letter under which the second claim notice was given to the qualifying tenants. And you can see that that letter is dated the 18th of June. So it's a day after the second claim notice was given to the landlord. And it has been held that this letter was a notice of withdrawal given to the qualifying tenants. And the first tier tribunal has held, and it's not in dispute, that it therefore follows that the notice of withdrawal was given to the landlord on the 18th of June, but it wasn't given to the qualifying tenants until the day after. So the point is, the issue in the appeal is, on the proper construction of section 86(2), if the notice of withdrawal must be served on all those persons in section 86(2), including the qualifying tenants, as required by subparagraph D, it would follow
what's
that
happened here is that the notices of withdrawal and of restarting have been contained in the same letters. Of course, there's no reason that that has to be the case, and indeed this case may be an object lesson in why it's not a very good idea. It could equally have been done by sending letters of withdrawal, followed up by letters of restarting or new notice.
That's absolutely right, my lord. As my lord says, perhaps this case is not a paradigm example of the best way in which it could be done, and that's why there were arguments about whether these letters were in fact notices of withdrawal.
Yes, because they firstly ran into your argument about the missing hyphen, which is now cleared out of the way, and then are left with the issue that's before us.
My lord, yes.
Which is the order of events.
Absolutely.
Might there be a reason why the qualifying tenants or the RTM company would want to avoid there being a gap between the withdrawal and the claim notice? I mean, sometimes people try and do this because they're worried that if they give you a space, something might happen. Is that a consideration in a case like this? I'm not aware of one.
I can't think of one on my feet, my lord, as to what could have been done in such a short time that would have prevented the RTM company from no longer being entitled to acquire the right to manage, is the honest answer to that.
Thank you.
So, my lord, I've now moved to my submissions. I think I've made my first submission already, but it is of critical importance, so I want to make it again, if I may. And that is that there was no failure to comply in this case, for the reasons I give in paragraphs 26 to 29 of my skeleton argument. The Upper Tribunal approached this issue on the basis that the qualifying tenants have not been served in compliance with section 86(2)(d). That's not right. They were served. There was a valid notice of withdrawal. That's now being determined by the Upper Tribunal. And so one simply follows the statutory provisions, and one is left with the simple conclusion that the notice of withdrawal was served on all those parties that it was required to be served upon, on the 19th of June, when it was served on the qualifying tenants, it must follow that the first claim notice was therefore not withdrawn until that date, and service of the second claim notice on the landlord the day before was premature, only by a day, but so be it. It was premature. The first notice was still continuing in force, and therefore the effects of Section 81, 3 and 4 are clear that the second claim notice is ineffective.
So, if the facts were different and you'd wanted the claim to have been withdrawn, and it had been served upon you as withdrawn, you might have faced in a different world an argument saying, well, actually it wasn't withdrawn at all because we didn't serve the tenants. So unbeknown to you, it was still alive. Even though we told you it was withdrawn, it didn't mean what it said.
My Lord, I accept that that is the logical consequence of my submission.
Right.
That it is
so
not
that if one doesn't break up notice, the purpose of notice, and the person to whom notice is being given, one can achieve any number of permutations of random results, whereby people who thought they've got notice or didn't think they've got notice end up having or not having notice, depending upon what happens to other people.
Yeah, yes, I accept that is...
Right, but you say, I mean, I understand, you just say that the statutory scheme says what it says.
It
That's
does,
your argument.
my Lord. It's quite straightforward, and I would say that I would submit, if that were not so, the qualifying tenants would not be specified in subsection D, or subsection, or there would be a slightly different provision similar to the requirement to serve the claim notice on the qualifying tenants. In section 79, there is a requirement to give a copy of the claim notice to the qualifying tenants. Find the provision.
It's 79 sub 8, isn't it?
Thank you, my Lord, yes. Page 4, tab 1. So what one can see in subsection 6, the claim notice must be given to ABC. That's the same ABC as in 86.2. But only a copy must be given. Whereas in 86.2, the notice itself must be given to the qualifying tenants, not just a copy of it. And I think I've made this point made this point yet. What I am submitting is in fact the Upper Tribunal's starting point when it analysed the provisions. If I could ask your Lordships to turn to tab 8 of the core bundle. The key paragraph is paragraph 53.
Yes.
So the point that your Lordship put to me is a point that was made by the respondent in the Upper Tribunal, and that was rejected. And there is no appeal against that finding, and there's no respondent's notice. the Upper Tribunal has held that it is not effective until and unless it is served on all of those persons in A to D. In my submission, that is the answer to this case. The Upper Tribunal fell into error by then going on to consider the principles that apply where there's been a failure to comply. But for the reasons I've already given, there was no failure to comply in this case. A notice of withdrawal was served on the qualifying tenants.
So you get that from 53, do you?
My lord, yes.
Because the first sentence is right. It doesn't say that withdrawal does not take effect until everyone specified has been served. It's not entirely clear to me where that point is then, you would say, rejected. I mean, I understand the other points that are made there, the importance of service. It seems to be a slightly different point to the point identified in the first sentence.
Well, I think the key sentence, my lord, is 5 lines down. The only action that affects withdrawal is service. And then the last sentence, section 86.
I understand that. And then the last sentence.
It's quite clear in my submission. It's not affected unless there's service on all those persons specified in A to D. And
yes,
and that must be right because.
But your case, as I understand it, is that withdrawal doesn't happen until the last date of the service on the last person. Well, you certainly don't get that from 86.
You don't get that expressly from section 86, my lord.
Well, I would say by any reasonable inference. I mean, a notice of withdrawal must be given to each person and then they're listed. But you have to say that that means that until the last person is served, the notice of withdrawal is ineffective.
That is my submission, my lord. And if it were not the case, you'd have the curious position where the notice was in force as against some people but not others. And in my submission, it's binary. Either it's in force or it isn't. And it remains in force until it's withdrawn or deemed withdrawn or it ceases to apply by reason of a statutory provision.
Does that not run contrary to the clear statement that an RTM company may at any time withdraw? I mean, there's plenty of judicial authority on what's meant by at any time. I mean, your case would potentially, and obviously we can all think of factual circumstances which are extreme, but your case would be that it's not at any time. It would be only when all the people in subsection 2 have been served.
Well, my lord, I would submit that that's not inconsistent. One would have to read those two together. The RTM company is entitled to withdraw the claim at any time. That's subsection 1. It does so by complying with the requirement in subsection 2. In other words, well, how does it withdraw its claim at any time? It does so by serving all those persons in A to D of subsection 2.
Is there a provision in 86 which requires any of those persons to know when any of the other persons got it?
There isn't, my lord, no.
Doesn't that perhaps tell you on something about the significance of when others got it? If there's no scheme whereby the landlord has to know when the qualifying tenant got the notice, and that's the...
Well, that is a reason that was given by the Upper Tribunal, and I would submit that the absence of any express provision on that does not affect its interpretation, and its interpretation is as I've submitted that it is. So that's all I had to say in respect of the primary submission. There was no failure to comply. If you're against me on that, then it's necessary to consider the consequences of non-compliance.
Before you go there, can I just break it down slightly? It strikes me that there are 2 points under the non-failure to comply. I just want to make sure I've understood where you're coming from on both of them. You say there's no failure to comply. I get that. But you also say, and that means that the effective date vis-a-vis the landlord is the date the qualifying tenants were served. And that's not necessarily the same as, you could be right about the first point and wrong about the second point.
That's right, my lord, yes.
And I'm just trying to make sure I've understood that you've understood that I'm thinking about it that way, and help me to know what you say about the second thing.
That is right, and what I say about the second point is what I've said about paragraph 53 of the Upper Tribunal's decision.
Thank you. Okay.
So now you're moving on to consequences. If you're wrong about on that point.
My lord, yes.
Yep.
The relevant principles are set out in Nat and Osman and Elim Court, and I've tried to summarise those in paragraph 31 of my skeleton. I don't think they're controversial or in dispute, and in fact I've lifted that summary from Lord Justice Lewison's summary in Elim Court, so your lordships would no doubt prefer to go there rather than to what I say. That's in tab 9 of the authorities bundle. And the discussion about the consequences of non-compliance starts at paragraph 49 on page 142.
Page?
Page 142 of the authorities bundle.
Thank you. Paragraph 39.
49, my lord.
49.
49 right through to the end of 56, which is marked in the margin. It may be helpful if your lordships read that now, because it is important.
Thank you.
My lord, several points were taken in Ealing Court as to why the claim should fail. They're adequately summarised in the headnote on page 129, subparagraphs 2, 3 and 4. The first issue was that the notice of invitation to participate did not include either a Saturday or a Sunday as one of the 3 days on which the Articles of Association could be inspected by the qualifying tenants, as required by Section 78(5)(b), and it was held that while that was non-compliance, it was a trivial failure and it didn't invalidate the notice. The second issue in subparagraph 3 of the headnote was that the claim notice was not served on the intermediate landlord of a single flat, and that landlord had no management responsibilities. And it was also held that that failure did not invalidate the claim notice. And then subparagraph 4, it was held that the person who signed the claim notice had authority to do so, but even if he didn't, that would have been a failure which would not have rendered the claim notice invalid. So those are the relevant principles, and the Upper Tribunal correctly identified those principles. I would submit that it fell into error in the application of those principles. The starting point, as I've said, is Section 81(4)(a) of the 2002 Act, which provides that the claim notice continues in force until it is withdrawn or deemed withdrawn or otherwise ceases to apply. And as I've said, the purpose of Section 86(1) is to withdraw the claim. That's a democratic decision of the members of the RTM company that they no longer want to proceed with the claim to acquire the right to manage. Going back to paragraph 53 of the Upper Tribunal's decision, as I've already submitted, Section 86 enables the withdrawal of a notice and sets out how it must be done, in other words, by service on all those persons specified. And so the purpose of Section 86(2) is, in my submission, to inform all those persons specified in A to D. That is self-evident from the fact that those are the persons specified. And if it were not a requirement to serve the qualifying tenant and to inform them, then there would be no subsection D of Section 86(2). So it is wrong, as the Upper Tribunal held, that the purpose of Section 86(2) is just to inform the landlord. It is not. It is to inform all those persons in Section 86(2). And that's because the effects of the acquisition of the right to manage, the acquisition of the right to manage affects not only the landlord, it affects other parties too, and that was described by the Deputy President of the Upper Tribunal in Triple Rose and Mill House. That's at tab 14 of the authorities bundle. At paragraph 12, if I could ask you to turn to page 201, please. Could I invite your lordships to read paragraph 12, please?
That the passage that was quoted by Lewis and LJ.
It was, yes. So,
Right, so we've got it
you've
already.
already read it. So my next point was that was referred to with apparent approval by Lord Justice Lewison. So the point is that the acquisition of the right to manage may well have a much greater effect on persons other than the landlord. For example, where there is a management company that is responsible for managing the premises, the acquisition of the right to manage is going to have a greater effect on the management company, because it's the management company that will lose its ability to carry out its management functions. So it's simply wrong to say that the main purpose is to serve on the landlord. That can't be right.
Would it be fair to say that the distinction the judge was drawing would be a distinction between the three categories A, B, C and the qualifying tenants? And I mean, you're quite right that the judgment doesn't mention a management company, but then there isn't a management company in this case.
No.
That matters.
Well,
I'm aware of.
it may well have been that's what she was thinking, but that's not what it says.
Right, you're right. Of course, the word is landlord. Yes,
and I accept that it's important to look at the position of qualifying tenants, but it is important in my submission that qualifying tenants are informed that a claim is being withdrawn. There will be, in many cases, qualifying tenants who are not members of the RTM company, and they are entitled to certainty as to who will manage the premises. For practical purposes, of course, they need to know to whom they should pay their service charge. So it's not as if the withdrawal of the claim has no practical effect on the qualifying tenants. It's clearly important that they also know what's happening with the claim.
I'm still, and forgive me for repeating a point that I put to you earlier on, but now that you've gone into this more deeply, struck by the fact that it would be much more likely, one would have thought, that a landlord in your position who had been given notice of withdrawal would be in a position of substantial complaint if they found that because not all of the qualifying tenants had been notified, when they had been notified themselves as landlord, somehow the withdrawal had not been valid. And it's on the face of it, the point that you pray and aid now would, in the great majority of cases, work against people in your client's position who'd been given notice of a withdrawal of a challenge to their position, which they found they then couldn't rely upon and might not discover for a long time had been invalid.
I accept that there may well be those cases. Whether or not it's the great majority, I beg to differ.
Well, you know, and I don't. But I'm thinking that the circumstances in which you pray this argument in aid are a very peculiar set of facts that happen to have arisen because of a sequence of correspondence. Whereas it's much easier to see how a landlord would be saying, "What do you mean this withdrawal of a claim against me was not valid when you told me it was withdrawn?"
Well, that is the logical consequence of my submission, yes. And I accept that there may well be cases where a difficulty arises for the landlord because of the interpretation that I am putting forward.
But in sense, when considering certainties, that's front and centre in terms of the certainty of a client such as yours. The certainty of other people that you're inviting us to consider is of course another consideration as well, but it's not your main concern.
It's not, but it's important to consider the qualifying tenant's position, as Lord Justice Lewison explained in Ealing Court and,
yes.
and Mr. Justice Fancourt in the Canary Gateway case. One has to focus on prejudice in the generic sense that the qualifying tenants may suffer, and that is why I make that point. And one can see that there are all sorts of factual permutations, as your lordship has said. One is not too far removed from this case, where there are rival factions in the building. Being careful not to give evidence because there are no findings on this, but if I can deal with it in the hypothetical, there are many situations where there are rival factions of leaseholders who are vying for control of the management of the premises, and one group steals a march on the other. Those qualifying tenants who are not taking the claim forward would want to know as soon as possible that the claim has been withdrawn, so that they may well take steps themselves to exercise their statutory rights. One can see, for example, that while an RTM, there can only be one RTM company in respect of any set of premises at any one time, but one can see how that other rival group of leaseholders may then want to join the RTM company and put themselves forward as a director and start taking decisions as to how to proceed with a further claim. So it is important for qualifying tenants in that sort of position that they are informed about the withdrawal of the claim, and that is a reason why I would say that the failure to comply is important. It's important for those qualifying tenants.
But in one sense, that's slightly removed from the issue we have to decide. Assume for this purpose that it is right, that it is important that the qualifying tenants receive the notice. It's still a jump from that to say that the withdrawal notice is not valid until they have all been given that notice, or putting it another way, that the withdrawal notice is valid as against their landlords until they've all received notice.
It's a different point, my lord, isn't it?
Yeah, but what I'm saying is I'm not necessarily sure you can jump from one to the other, assuming that you're right, that it's important that the qualifying tenants get notice. That still seems to me to be a different question, and not necessarily, it's certainly not decisive of your principal point, which is that it's not valid until they've all received a notice, not valid in relation to your client.
My lord, yes, I can see that point is troubling, my lord. I don't think I can amplify what I've said.
I understand
that.
But I'm just the points about the importance of service on the qualifying tenants seem to me to be potentially, at any rate, a yes, but so what? Potentially.
Yes, I mean it depends to some extent.
What I'm saying is you may be right on this, but that may not get you home.
No, if your lordship takes a different view on whether it's necessary or whether it takes effect.
Yeah.
Yeah.
Well. But anyway, your submission is that effectively, looking at both Ealing Court and Triple Rose, it is important that the qualifying tenants are served, and it's wrong to say it's just a matter for the landlord.
In a nutshell, my lord, yes.
Yeah, I understand.
The next point I wanted to make was if one looks at Lord Justice Lewison's pointers in paragraph 52 of Ealing Court, and that's at tab 9. Page 143 of the authorities bundle. Paragraph 52, letter G. All of the pointers to which he refers point in one direction in this case, and that's in the argument in favour of my client. Because the requirement is in the statute itself, in section 86(2). It's not in subordinate legislation. And it's quite easy
Sunday
for
was in the statute itself, Mr. Upton.
Pardon, my lord.
Saturday, Sunday was in the statute itself, if I remember rightly. the requirement to give notice that you could come and see it on a Saturday and Sunday was in the statute.
My lord, it is. It is. That's absolutely right. And they're only
And
pointers.
so was the requirement to serve it on the intermediate landlord.
My lord, that's right. And they are only pointers. They're not. I don't say they're decisive. But
we're moving with in this section of paragraph 52 into missing information, aren't we? In other words, notices that don't contain the full information required. Is that in the second half of paragraph 52? Isn't he moving to consider those particular matters, having earlier on in that paragraph made some general points about the critical importance or secondary importance of non-compliance within the statutory scheme?
it's right that this is said in the context of missing information. One can see that from the sentence immediately before one useful pointer.
Yes.
But I would submit that they are of more general application.
But I mean, I had stopped you before you'd gone on to the second and the third points, but these are examples of the main point, which seems to arise in the middle of that paragraph, doesn't it? To do with the relative importance of the requirement that has been not followed.
Yes.
In the context of the scheme.
Model, I agree. That is the context in which these comments are made. But as I said, I would submit that they are of a more general application, and when one looks at them, they all point in my client's direction. The third one, which I was going to mention, is the fact that another notice may be served immediately. Well, that is also the case with a notice of withdrawal. The next case I wanted to refer your lordships to is a decision of Mr. Justice Fancourt in the Canary Gateway case. That's at tab 7. The issue which is relevant to this appeal.
What page is it at?
Well, can I ask your lordships to turn to
I'm
page
just looking
91?
in the bundle of authorities. I'm not making complaint about it, but this wasn't bookmarked, so tabs don't help me. What's the paragraph?
Page 91.
Thank you. Paragraph 77, did you say?
I'm going to ask you to start at paragraph 81. The issue or one of the issues in this case was whether the failure to serve a notice of invitation to participate on a qualifying tenant who was also a landlord rendered the claim notice invalid, and it was held that it did render it invalid. And Mr. Justice Fancourt's analysis of the relevant principles starts at paragraph 81. If I could ask your lordships to read 81 through to 84, please. So, Mr. Justice Fancourt is construing section 79.2 and he identifies 4 material factors in paragraph 84, and I would submit that it's helpful to apply those factors to the instant case when construing section 86.2. The first is the objective importance to the statutory scheme of notice of withdrawal being given to every qualifying tenant. Well, I've already addressed you on that it's important that they have certainty for the reasons I've given. The second
that's the point we've been wrangling over up until now, because
yes.
You're saying we have to consider the tenant and the landlord, or the landlord and the tenant.
Yes.
Yes.
In a nutshell, it is important that the qualifying tenant is given a notice of withdrawal in the.
So that's the first point.
That's the first point. The second point is the relative ease or difficulty of compliance. So how easy or difficult is it to serve the qualifying tenants with a notice of withdrawal? Mr. Justice Fancourt deals with that in paragraphs 86 and 87 in the context of notice of invitation to participate, that the reasoning applies with equal force to a notice of withdrawal, and he concludes that it in fact is very easy to serve the qualifying tenants. So that's a point in my client's favour. The third point in paragraph 84 is the risk of non-receipt, and Mr. Justice Fancourt deals with that in paragraph 88 and concludes that Parliament has put that risk onto or allocated that risk to the qualifying tenants, and I would submit that the same would apply with a notice of withdrawal for the reasons that are given by Mr. Justice Fancourt. And the fourth is the likely consequences of invalidity resulting from non-compliance. Well, the consequence of a failure to serve a notice of withdrawal is that the claim notice continues in force, and that the RTM and its members are liable for the costs until it is withdrawn. But the RTM company's entitlement is not lost, it's not prejudiced in any other way, and it's very easy to serve further notices. So I would submit that that's also a point in my favour. So all of those points assist my interpretation, I would submit.
Just on the costs thing, I'm trying to remember, if there are no proceedings in the tribunal, the RTM company is never liable for the costs of a qualifying tenant?
The RTM company and the qualifying tenants are liable for the costs under section 88(1).
No. I know the RTM company and the qualifying tenants are liable for other people's costs, but the other people's costs for whom they may be liable are only the landlord or the management company's type of thing, unless there are proceedings.
My lord, yes.
So in the present case, the qualifying tenants who didn't get the notice until a day later, at that point they wouldn't have had costs that the RTM company could have been liable for.
Unless they were members of the company, that's correct.
Yes, they might be liable to pay. They might be yes, they might. Yeah. They wouldn't have been able to receive as receiving parties. They wouldn't have been able to get costs.
That's correct, my lord.
That's what I'm trying to say.
Yeah, I understand.
And Mr. Upton, is this right, that you've taken us to the Canary Gateway case, and I understand your submissions on that, and that came after the decision in this case?
It did, my lord, yes.
Because that dated 26 November 2020, and the decision that we're concerned with is June.
That's correct, my lord, yes.
Yeah.
And while we're in Canary Gateway, it may well be worth looking at paragraph 92, which is perhaps not legally relevant, but it deals to some extent with a point I've no doubt my learned friend will make about the landlord not being the guardian angel of the tenants, than that. That is that it is simply a consequence of the proper interpretation of the statutory requirements. So it was held in that case that the claim was invalid simply because of the way the legislation is drafted, and I would submit that's the same in this case.
I see from that paragraph there's another Law Commission report into this area of law. I could name a number of areas of law that have never been the subject of a Law Commission report that would be really quite useful. But they spend all their time dealing with landlord and tenant and land law. It's quite extraordinary. You always get references to the next set of proposals to revamp land law, or in this case, landlord and tenant law.
We're just waiting for the legislation.
Yes.
I've already a point I wanted to make in respect of the consequences of non-compliance is the point about section 79 (6) and the copy of a claim notice where there is no similar provision in section 86. I've made that point already elsewhere, but it's also relevant to looking at the consequences of non-compliance in my submission. We've looked at the...
Sorry, Mr. Robson, just forgive me. I understand the point you've made that if you if you compare the provisions in section 79 and the provisions in section, I've now forgotten the name of the section, the one we're talking about, there's a difference because in the 79 version, essentially the notice has to be served on the landlord and the similar entities, but only notified to the qualifying tenants, whereas in the withdrawal provision, they're all lumped together. I understand it. That's a perfectly legitimate, obviously, point for you to draw attention to. Can you tell me what purpose could you ascribe to that distinction having been drawn?
Well, it indicates that it is more important for qualifying tenants to be given a notice of withdrawal. It's important in the statutory scheme rather than just being given a copy.
But why? If they only need a copy of the originating process, why do they need something more than that for the withdrawal process? That's what I'm trying to ask you.
For the reasons I've given in terms of the effects on qualifying tenants, in terms of certainty and how their statutory rights are affected and how they may wish to pursue a claim themselves.
Right. I mean, I don't want to get into too much of a dialogue with you. My sense of it is that those reasons actually would apply just as much to the originating process as they would to the withdrawal. I don't understand how the points you've made justify a difference between these two steps. I understand why you say it's important, why they indicate that it's important that the qualifying tenants know about what's going on. I get that completely. But what I'm struggling with at the moment is to see why those points justify a difference in the scheme that you're drawing attention to.
My Lord, I don't think I can give an answer to that. If I think of one, perhaps I can address you in reply.
Of course.
If it's a point my learned friend makes. I had two final points. I think I've already dealt with the position on cost to some extent. Very briefly, the Upper Tribunal held that it was one of the purposes of serving a notice of withdrawal, that it drew a line under the liability for costs. That's at paragraph 63 of the Upper Tribunal's decision. Page 112 of the bundle. Fifth line down. One of the purposes of serving a notice of withdrawal is to draw a line under the RTM company's liability for costs. It cannot be right that in every case a landlord can assert potentially months after service of the notice of withdrawal that in fact not all of the prescribed recipients were served, and therefore the RTM company's liability for costs continues beyond the date of the notice. I would submit that that's not right. There are many cases in which it would be perfectly reasonable for the landlord to be able to recover its costs after it has been served with a notice of withdrawal, where the notice of withdrawal has not been served on the qualifying tenants. For example, where there are proceedings and where the RTM company has not informed the tribunal, and proceedings continue for some time.
I'm sorry to be dragging behind your argument here, but I was just looking at Canary Gateway again to see what the argument that Mr. Justice Fancourt was addressing was, because he had to deal in quite a long judgment with 3 issues, and we're only concerned with the last one, aren't we?
We are, my lord, yes. Sorry if I
was picking it up at 71, which is on printed page 87.
Yes, I'm sorry if I haven't.
No, not at all. You were
detail.
going at good speed, but the point that he was having to consider there was whether depriving all the qualifying tenants of the opportunity to join in by the giving of notice was sufficiently important to make the failure fatal to the subsequent notice. That 71 sums up what he was addressing there, doesn't it?
Yes, although what he was actually deciding, if one turns to the statutory provisions, he was actually construing section 79(2), which on the face of it specifies the consequence of non-compliance. So you have the statutory requirement in section 78 to give the notice of participation. Very often the statute doesn't then specify what the consequences of non-compliance are, but that's not the case with a failure to comply with section 78, because section 79(2) expressly provides for the consequence of non-compliance in that you cannot give a claim notice, and that is the particular provision that he was construing, and the answer is, as my lord has identified, that it was sufficiently important in the context of the statutory scheme.
But I mean, it seems to me that the point that you draw from the final paragraph 90, which is that Avon in that case had succeeded, although it was running an argument that was really of no direct relevance to itself, but was raising arguments on behalf of other participants in the scheme.
Yes.
But nevertheless, it was entitled to do so. But that is because it was important to those other people in the scheme.
Yes, that's absolutely right.
The 14 days notice actually could have made a difference to the way that everything was constituted. It could have made a difference to the 50% and so forth.
Yes.
So it isn't just I'm entitled to rely on things that are not of no direct relevance to me. I can rely on things that are of direct relevance to everybody else, provided they're important to the other people.
Absolutely, my lord.
So the question here is really whether it makes a ha'porth of difference that they got it on Wednesday rather than on Monday.
Yes, the question is whether it's important in the context of the statutory scheme that
for the other participants in the scheme.
Yes.
Yes.
And I hope I've given my answer as to why I say it is important.
Yes. Thank you. Sorry, I pulled you back into an earlier argument, so please go on.
You were dealing with the cost point, had you?
I was dealing with the cost point. I think I've made that point, my lord, in that I simply don't accept the reasoning of the Upper Tribunal that there may well be cases where the landlord should be entitled to recover its costs after it has been served with a notice of withdrawal.
I understand your point about that. In one sense, though, the passage in the judge's judgment at 63 that you drew our attention to, in one sense ties back to the withdraw at any time point, because she is there, I think, saying, well, they must be entitled to withdraw, and once they've withdrawn, they shouldn't be carrying on incurring a cost liability. So I think there is a link to the point that we debated before there. You say, well, there will be circumstances where it's justified.
My lord, yes. And my very final point is that I accept that there may well be cases where it is not possible to serve all of the persons specified in section 86(2), and the example was given in the Upper Tribunal of a company that owned several flats that had gone into liquidation. What I would say about that is that that isn't this case, that the position may well be different on those facts, that it may well be that applying the principles in Elim Court, that wouldn't render a notice of withdrawal invalid on those facts, but that's not something that falls to be determined on this appeal. This case is very different. There was an entire class of person that was not served, i.e. all of the qualifying tenants.
Well, they were served, but not on time.
If you're against me on my first point.
Yeah.
My lords, those are all the submissions that I wanted to make. Can I assist the court on any particular point?
No, Mr. Upton, thank you very much. That's been very helpful. Yes, Mr. Rainey.
My lord, if I can break this down into three parts. First of all, I propose to deal with what the Upper Tribunal said at paragraph 53, which is a central plank of Malone Friends submissions. Secondly, I would wish to trespass on your time and go back through the statutory provisions for the purposes of showing how little the qualifying tenants have to do in the statutory process, which is a fundamental point about when you get to the importance of a notice of withdrawal being given to the qualifying tenants. The gravamen of my submission being they effectively have no real part in the statutory process after they have received the notice of intention to participate, which, as your lordships have seen from Canary Gateway, is an important point. But after that, they effectively drop out. And then the third thing, or the third part of my submissions is to go through the consequences of it, and I hope demonstrate that this is clearly one of those cases where the consequence of not serving the qualifying tenants does not affect the validity of the notice of withdrawal as given to the landlord party. About paragraph 53 of the Upper Tribunal's decision, your lordships have seen it. It's on page 109 of the core bundle. Effectively, I don't see it as saying what my learned friend says it says. What the Upper Tribunal was dealing with was a submission that there were two parts to section 86, namely that there was some concept of withdrawal and then a separate concept of giving a notice to the recipient set out in section 86(2). And all that the Upper Tribunal is doing in the rest of the paragraph after the first sentence is saying, well, no, there's simply one part of section 86, which is that you withdraw by giving a notice of withdrawal. And Judge Cook rightly says it'd be absurd to suggest that there could be a withdrawal if you served one qualifying tenant but didn't give any notice to the landlords at all. And then at the end, and this is the paragraph my learned friend rests on, Judge Cook says section 86 enables the withdrawal and sets out how this is to be done, namely by service on all those specified. All she's doing there is reciting the statute. She's clearly not finding that giving the notice or service of the notice on the qualifying tenants is essential. And it's obvious that she's not finding that because paragraphs 54 through to the end of the decision demolish that argument. So paragraph 53 simply can't be read the way my learned friend seeks to read it. He's also, if I may respectfully suggest, guilty of taking it out of context. You can't pluck one paragraph out of a decision and say, well, 53 suits me. I don't like 54 through to 63, which I don't. They're not divisible in my submission. Thirdly, I would submit that he's in effect pulling himself up by his own bootstraps. His argument assumes the answer. It only works as a construction of paragraph 53 if you've already assumed that giving the notice to the qualifying tenants, all of the qualifying tenants, is essential to its validity as given to the landlord and other parties under A to C. He's effectively assumed the answer to the very question which we are seeking to answer in this case, and which is properly answered by applying the Elim Court approach of construction, which is to look at the statutory scheme. Is it a procedural provision? Well, yes, it is. And then assess the importance of compliance with the particular procedural provision within the overall scheme. We're only dealing, for the avoidance of doubt, with subparagraph D, serving the qualifying tenants. As Judge Cook rightly found, it would be absurd to suggest that you could effect withdrawal by serving the qualifying tenants under D, but not serving the landlord under A, B or C, or serving the manager parties under B or C. That's not what this case is about. We're only looking at D. And the fourth point is my learned friend is effectively trying to draw a distinction without a difference, because he's trying to satisfy your lordships that actually there is compliance in this case, and therefore that there's no room for Elim Court to operate. But that doesn't work as a conceptual construction. Where a statutory procedure requires that something is done before a specific time or before a specific next step, which in this case the next step being the service of the second claim notice, then the distinction between doing the act or taking a step late and not doing it at all is a distinction without a difference. I suppose to test it this way, as I understand my learned friend's case, my client is worse off because it gave the notice to the qualifying tenants on the day after than it would have been if it hadn't given notice at all. Not giving notice at all is what happened in Elim Court, and indeed the Lexham case, which is also in the bundle. There was a failure completely to give a particular notice to one of the landlords. And in both those cases, the Court of Appeal in Elim and the Upper Tribunal in Lexham said that on the particular facts and in the particular circumstances, it wasn't essential to give the notice to that particular landlord because they had no management responsibilities. As I understand my learned friend's argument, or his first argument, the decision would have been rather different if someone had woken up to the fact that they should have given a notice to that landlord and given it to that landlord a couple of weeks later. That would have then been fatal because the appellants in those cases would have said, they did comply, they just complied late. But that's not how it works. In effect, in Elim Court, the date that the notice was given to all of the other landlords was the date that it was given to those landlords, and it becomes irrelevant as to when or if notice is given to the extra landlord, if I can call it that, who didn't have any management responsibility. And I would submit that if one pauses for a moment, any submission which comes to better never than late is clearly wrong. And it is the logical consequence of the respondent's case, which was accepted by the Upper Tribunal, is that the qualifying tenants did not need to be served at all in order for the notice of withdrawal to be valid against the landlord parties. And because of that is the construction which the Upper Tribunal came to, and which I invite this court to approve, it becomes irrelevant whether the qualifying tenants were served late or at all, because the construction of the statute is that the notice of withdrawal was valid against the landlord parties on the 18th of June, and it was irrelevant whether a notice was later given to the tenants on the 19th of June. So this case, I submit, is about Elim Court and the question of construction of Section 86. If I can ask your lordships to go back to the statutory scheme, which your lordships find, as you know, at tab 1, page 1 of the authorities bundle. And if I can go through this as quickly as possible, bearing in mind what I'm seeking to establish is how little the qualifying tenants
So just before we embark upon this, I had open in front of me the judge's decision at paragraph 61. Does that encapsulate the point that you're embarking upon by reference to the provisions themselves? So page 111.
Yes. Just finish the deconstruction of bundle. Yes. The beginning of paragraph 61 is effectively the point I'm embarking on now. The end of paragraph 61, and indeed the first line of paragraph 60, make good the point I was just making, that what the Upper Tribunal correctly realised is it doesn't make any difference whether it's given at all to the qualifying tenants. It says, accordingly, if the appellant had not been served, the notice would not have been withdrawn. But then it says, at the end of 61, the consequence of not sending it to the qualifying tenants is not that the withdrawal is ineffective, and then service 1 day late does not make any practical difference. But the point is that the Upper Tribunal is dealing with the consequence of not sending.
So your reference in a moment to the statute itself is in support of the correctness of this.
Yes, the lack of importance of the of 86(2)(d) in the statutory scheme. My Lord, I'll skip over, if one has the statutes at beginning at page 1, I'll skip over paragraph 70, section 72, which is premises to which this chapter applies. The building qualifies. The next page deals with section 73. I will pause there a moment. The RTM company is at the heart of the statutory scheme. By forming an RTM company, this is how the qualifying tenants get to exercise right to manage. And section 73(4) effectively means there can only ever be one RTM company for one set of premises. The qualifying tenants can join it, or they can not join it. They can participate by being members of the RTM company or not. That's the only thing they can do. They have no independent functions within the statutory process. Everything goes through the RTM company. So the only choice they ever make is to join or not join. Turning to section 74 on the next page, this sets out who can be a member of the company. During the qualifying stage, when right to manage is being sought, principally it's the qualifying tenants of flats who are the members. Landlords can join later, but 74(1)(a) says that the basic membership is the qualifying tenants. Section 78 is the next relevant section. Your Lordships have seen it. This is the notice inviting participation. As my learned friend took you to, the RTM company has to give such a notice to any person who is a qualifying tenant but who's not a member and hasn't agreed to become a member. And they must do that before making a claim to acquire the right to manage. This is plainly of great importance in the statutory scheme, hence Canary Gateway is rightly decided, because as I've said, the only thing that tenants in the building can do is join the RTM company. That's the only way they can influence this process at all. And because you can only have one RTM company for the property, it's very important that non-members are told about this and given the opportunity to join. In fact, if one thinks about it, some qualifying tenants might not even know the RTM company exists, because to form it, of course, you just apply to Companies House. So the first they might know is when they get the NIP. So it is clearly of crucial importance in the scheme. And just pausing there for a moment to deal with one point which my learned friend raised, the spectre of rival groups of qualifying tenants. Well, if there is some group of qualifying tenants who don't want RTM, what they're supposed to do is they're supposed to join the right to manage company, potentially take it over, appoint directors. That's how you do it. You get the notice of intention to participate, and then they think it's assumed when the statute was drafted that they perhaps want to join in to push RTM forward. But at least in principle, they could join and say, we don't want RTM. They could join at any stage in the proceedings to cause the RTM company to withdraw the claim. But everything goes through the company. So the NIP under section 78 is clearly very important, but that's where things stop procedurally. After that, there's no role of any significance for the qualifying tenants in the procedure. So, taking you very briefly through the rest of the provisions to make that good. Section 79 is the notice of claim to acquire the right. First point to make is that although this might look procedural only, this is actually substantive as well, because in the middle of section 79, it tells you what kind of RTM company is eligible to give a claim notice at all. So it's subsections 3, 4 and 5. A claim notice can only be given by an RTM company, which is if there are only two qualifying tenants, both are members, or in any other case, a 50% set of qualifying tenants are members of the company. That's not merely procedural. That's fundamental to jurisdiction and eligibility. You will appreciate I've slightly trespassed onto where we might go with the respondent's notice, but the short point is that a notice which is given by an RTM company which doesn't have the requisite membership is something which was never able to be given under Section 79, and it is writ in water. It's not a valid claim notice at all, and nothing else in the procedure needs to be complied with. The second point, which the learned friend pointed out rightly, and I emphasise, is that giving a valid claim notice under Section 79 may, without more, lead to the acquisition of right to manage. And that's because in default of a counter notice, right to manage is acquired on the date specified in the claim notice. 3-month date, which the learned friend showed you when he took you to the claim notice. That is another reason as to why a notice which is given by an RTM company which doesn't qualify to give it because it doesn't comply with Section 79(5) is a nullity. Because if it weren't a nullity, you'd have the extraordinary situation that an incompetent company was able to take management away from the landlord. Section 79(6) is important because it tells you who the claim notice must be given to, which is, as my learned friend says, it's landlords, third parties, and tribunal-appointed managers. The claim notice is not given to the qualifying tenants. The qualifying tenants only have the right under Section 79(8) to be given a copy. And there is authority in the bundle, the case of Abu Hamdan, which my learned friend hasn't challenged, which says that you don't need to give those copy notices in order for the notice of claim to be valid against the landlord. It's fairly obvious, I would suggest, from the statutory drafting, because giving a notice and giving a copy are entirely different things. So we start from the proposition that the claim notice doesn't get given to the qualifying tenants at all. So one asks, why is it critical that a notice of withdrawal is given to the qualifying tenants? The obvious answer is it isn't. Section 80 is the contents of the claim notice. I said you can gain right to manage by default, and I referred to a date. You get that from, your lordships will take that from subsection 7, section 80, which requires that the claim notice must specify a date at least 3 months after the counter notice date on which the RTM company intends to acquire right to manage. That is the default date for acquisition of RTM if there's no response from the landlord parties. Section 81 is the supplemental provisions, which include the provisions at section 81.3 and 81.4. 81.4 saying, section 81.3 then saying that if premises have been specified in a claim notice, then you can't have a subsequent claim notice for the same premises so long as the earlier one continues in force. 2 points there. I mean, that, again, this is relevant if we got to the respondent's notice point. That would mean a claim notice validly given under section 79 and not one which was given by an incompetent RTM company. But what my learned friend said when asked what the purpose of section 81.3 was, he said it was to ensure that there was no duplicative process of right to manage, no competing notices. I'm inclined to agree that must be what it's for, but that's a point against him because the qualifying tenants don't have any participation in the process. So in a way it's of no consequence to them, or no real consequence, whether there's a duplicative process or not. It's important to the landlords Section 81.3 presumably intended to ensure that landlords don't have to deal with multiple overlapping claim notices. But it's really of no particular significance to the qualifying tenants because, as I say, they don't have any part to play at this stage. If one then turns to section 84, which is internal page 6 of the statutes, the counter notices, section 84.1 tells the reader who is entitled to give a counter notice. The persons entitled to give a counter notice are those who are served under section 79.6, not the qualifying tenants. So no matter what the qualifying tenants feel, they can't give a counter notice. The second point about it is that the counter notice from the landlord goes only to the RTM company. This goes to Malone Friend's point about the tenants needing to know where they are about right to manage. They won't know whether the landlord or any landlord is given a counter notice because there's no requirement that they're told. Section 84.2 then requires sets out that the landlord has to admit or deny the claim to right to manage. Section 84.3 then says that if there have been any counter notices from any of the served parties which denies the right to manage, then the company may apply, in effect must apply, to the tribunal for a determination. Pausing there a moment, as you can see from the heading to this case is RTM company versus landlord. You don't join the qualifying tenants to your application to the tribunal. They don't have any part to play in that. Section 84.5 says that if the RTM company has given negative counter notice, if the RTM company has been given, is in receipt of negative counter notices, then it doesn't acquire right to manage on the default date. It only acquires right to manage if either it's finally determined that the company is entitled to acquire RTM, or the counter notice giver agrees in writing that the company is entitled to acquire RTM. The qualifying tenants will not know whether either of those two things have arisen. To take the example, if your lordships were with me and dismissed this appeal, then the effect would be that the RTM company would acquire right to manage 28 days after your lordships handed down judgment. 28 days to allow for the time for applying for permission to the Supreme Court to expire. That would be when your judgment was final. But your lordships, this court is not going to serve the qualifying tenants with the judgment. They've got no way of knowing what the date of RTM is. It will depend entirely on this court. It's a public document, they could find out, somebody could tell them, but there's nothing in the procedure. So all this talk about the certainty and the qualifying tenants needing to know where they are, it is, with respect, a complete illusion. They would depend on being told voluntarily by someone else. And then one gets to section 86 and the withdrawal of the claim notice. Your lordships have already looked at it. It's a very short section, but I submit this as a very, very powerful point against my learned friend. Section 86.2 splits into two parts. A, B, and C mimic section 79.6. D, qualifying tenant, is the counterpart of section 79.8. There is no... It's very easy to see why potentially you mimic section 79.6. You give a notice to the landlord, you give the notice of withdrawal to the landlord. But no explanation has been given as to why it is of crucial importance to give the notice of withdrawal to the qualifying tenants and each of them. And there just isn't an answer to it. I mean, it may be it's not for the first time, not particularly good drafting. It would be more logical if it said you give a copy. But as a matter of construction, section 79(8), the fact that you only ever give a copy to the qualifying tenants, is a very powerful substantive point against my learned friend. In a sense, he can pray in a language. They didn't repeat the use of the word copy. But in terms of substance, section 79(8) is the very clearest pointer there could be that it is not essential to validity to serve the qualifying tenants.
So you say that A, B and C mimic 79(6) and D mimics 79(8).
I do.
I mean, it draws those two things together, albeit you accept that this doesn't refer to a copy.
Yeah. Yes. I take on the chin my learned friend's linguistic point.
Yeah.
But I turn it back on him substantively. It's very much against him. And you also get the very odd point about what effectively happens here. So in this case, the tenants don't get a copy of the first claim notice. It's essential that they are actually served with the notice of withdrawal, my learned friend says, but then they only get a copy of the subsequent claim notice. And in my submission, that doesn't make a great deal of sense as a statutory construction. It would make much more sense if the middle step, the notice of withdrawal, was not held to be essential to the validity of the notice of withdrawal as given to the landlords, who really do have to know. And indeed, there is clear potential duplication because, as I've said, at the second claim notice, only a copy needs to go to the tenants, and it's not actually essential to validity that they get a copy either at all or at the same time as the landlords are given the original. But yet the learned friend's construction drives you, in effect, to serving the qualifying tenants twice, potentially. Because he would say, oh, no, you have to actually serve them with the notice of withdrawal. You can't wait until a date when you give them the copy notice, as in this case, where they're given the copy notice a day later with the notice of withdrawal. And I say that that is an unlikely construction. And duplication of service increases the chance of a failure in the procedure and just increases the opportunities for a difficult landlord to find reasons to object to the claim notice. Furthermore, if one thinks about Section 86 and withdrawal, there is no step which the qualifying tenants can take in response to that which they can't take anyway. Because, as I've said, the only thing that the qualifying tenants can do is either joining the RTM company and trying to influence it qua member, or not being a member, perhaps leaving the RTM company. Those are the only things they can do, and they can do those at any time in the process. The deemed withdrawal proceedings, the deemed withdrawal provisions at Section 87, I won't spend very long on, save to say that the qualifying tenants, again, are not party to any of this because they won't be parties under Subsection 1 to any application to the Tribunal. They wouldn't have to be served with any application which was made to the Tribunal to withdraw a claim, and they wouldn't be sent any agreement in writing under Section 87(3). I don't think I need to spend very long on the costs provisions at Sections 88 and 89, save to make a couple of clarifications. First of all, Section 88(3) is a very unusual and, with great respect to Parliament, unfair example of one-way cost shifting in English law, in that the RTM company is liable for the landlord's costs if it loses, but if the landlord loses, the RTM company can't get its costs in the Tribunal. So the basic position is the RTM company can never get costs against anyone else. But the Upper Tribunal is right to note that the giving of a notice of withdrawal under Section 86 to the landlord brings a halt to the liability for landlord's costs. And that is yet a further reason why one might think it's important to serve the landlord and not to serve the qualifying tenants. So I think that that's all I wanted to say about the general statutory scheme. As I've gone along, I've probably repeated myself any number of times, but I hope that I have made good the proposition which I started with, which is that if you look at the overall statutory scheme, then one can see that the qualifying tenants do not have an important part to play in the procedure after the point of notice of intention to participate, which entirely supports the Upper Tribunal's reasoning, applying Elim Court, that it's not essential to serve the qualifying tenants in order for the notice of withdrawal to be valid against the landlord parties. I don't, as a result of this, accept the submission which Malone and Friend made, which is that essentially the landlords and the tenants are of equal importance in the procedure. They're not, and indeed, if one looks at Elim Court, I can ask you very briefly to go back to that, which is at tab 9 of the bundle of authorities. To look at page 134, where you'll find 134 of the bundle, paragraph 6 of the judgment. Lord Justice Lewison, at paragraph 6, quoted from part of the consultation paper, and he makes 2 points there. First of all, that the procedure should be as simple as possible to reduce the potential for challenge by an obstructive landlord. With all due respect to the appellants, this is an obstructive landlord case. Then he says, at the same time, the legitimate interest of the landlord in the property should be properly recognised and safeguarded. So the focus in my submission is very clearly on the landlord parties. It is the landlord parties who will lose their management powers if right to manage is acquired, and it is they who are the focus of the statutory procedures and the protections, and it is they, and they alone, who need to receive the notice of withdrawal. In going, so to draw those strands together, the Upper Tribunal said that the purpose of the notice of withdrawal is purely information. To be clear, the purpose of serving the notice of withdrawal on the qualifying tenants is purely informative. That's what the Upper Tribunal meant, because Judge Cook was only dealing with a case under D. I would entirely accept that the purpose of serving the landlords under A, B and C, and I think it's implicit in Judge Cook's judgment, that's rather different. But the purpose of serving the tenants, it can only be for information. These factors also can be repackaged into one of the other Elim factors, which is there any prejudice in the objective generic sense to the qualifying tenants if they don't get served with the notice of withdrawal? And again, the statutory scheme answers that question. The answer is no. In the generic sense, there's no prejudice to the qualifying tenants if they don't receive the notice of withdrawal, because there's nothing they could do about it anyway, other than, as I say, to...
You would say still less if they received it on Monday, Tuesday or Wednesday.
I do, although I think I have to be realistic. Where you have a statutory deadline, effectively, which is here, you have to have given the notice of withdrawal before you can serve the second claim notice, then I think I would accept, and the Upper Tribunal said, well, it doesn't matter whether you get it late or not at all. So I'm putting it in that way, but there's no generic prejudice to the qualifying tenants if they don't get the notice of withdrawal or get it late, as in this particular case. The position of the qualifying tenants, I submit, can be contrasted with the position of the landlord parties. But we know from Elim Court itself that although Section 86, that although you must serve landlord parties, must doesn't actually mean must serve all, because the decision in Elim Court is that if a landlord party has no management responsibility, then it's not essential to the validity of a claim notice to serve that particular landlord. That is the decision in Elim Court. And it was then followed by the Upper Tribunal in the Lexham case, which I can take you to, but since it effectively follows Elim and gives the same answer, I'm not sure that I need to spend the time taking your lordships through it. But I rhetorically would say this: if landlords who have no management responsibility do not need to be served with a claim notice, by extension one might think they didn't need to be served with a notice of withdrawal, if that came up. And if that category of landlord didn't need to be served with a notice of withdrawal, how is it consistent with Elim Court for my learned friend to submit, but all the qualifying tenants need to get it, when they have far less to do with the procedure? Because although Elim Court says you don't need to serve landlords without management responsibility, it's still the case that within the statutory scheme, they would have had the chance to serve a negative counter notice if they had so chosen. But they don't have to be served with the notice. That's what Elim said. And so I submit that my learned friends really boxed into a corner by the reasoning and the result in Elim Court. I've already dealt with the point that one doesn't have to serve all of the qualifying tenants, or indeed any of them, with a claim notice. You simply serve them with a copy. So there is a potential trap built in here if my learned friend is right. You might have had difficulty serving a qualifying tenant, but it wouldn't have mattered at the claim notice stage. According to my learned friend, however, you then fall into a trap if you need to withdraw it, because at that point you really do need to serve all of the qualifying tenants. And although I have to accept that in Canary Gateway, Mr. Justice Fancourt held that it's actually quite easy to serve all of the qualifying tenants because you can just serve them at their flat, I would respectfully suggest it's not quite as easy as all that, because I think Mr. Justice Fancourt is assuming that it's easy to get at someone's flat. It's not always easy, because if one thinks about a block of flats, it's actually very difficult to get to the front door of someone's flat through...
Are we straying? Are we straying a little away now from our core task here? Is this...
No, this is not really straying, because one of the Elim pointers is how easy it is to comply. And my learned friend says it's very easy to comply. In Canary, Mr. Justice Fancourt said it's very easy to serve all the qualifying tenants because you can just serve them at their flat, and there's a deemed service provision under Section 111. And just pointing out, it's not necessarily so easy to serve all of the qualifying tenants at the flat, because in some buildings, particularly to take his example of the factional split building, there may be flats where they're behind several security doors, or it's the caretaker's flat in the basement to which the tenants don't have access. There's no post box in the common parts. It's not necessarily so easy to serve the qualifying tenants. And we're dealing with quite a small block here. RTM could be acquired in respect of a block with hundreds of tenants, hundreds and hundreds. And the capacity for something to go wrong is, I would submit, quite extreme in that kind of circumstance. Another Elim pointer which I should deal with in my response is the point about whether or not what are the consequences of invalidity. And my learned friend says, well, you can simply immediately serve another counter notice, so there's no problem with invalidity of the counter notice. The notice of withdrawal. That's not actually right. It's not the only circumstance you can serve a notice of withdrawal, but a notice of withdrawal is quite likely to be served in the kind of circumstance you get here, where you had a negative counter notice and someone's going to start again. In those circumstances, you won't know that your notice of withdrawal is being said to be invalid until the landlord's given the counter notice in respect of the subsequent claim notice. Exactly what happened here. My learned friend is saying quite neatly, says, oh, well, it doesn't matter if it hadn't been given on the 17th, just give another one. It doesn't work like that. You don't find out there's a problem until the landlord takes the point with the next counter notice, on the next claim notice. And this cycle can go on and on, because, of course, by then, you're too late, if you wanted to try and proceed on the first notice, because you will have been deemed withdrawn. And the attritional warfare, which the courts and tribunals have noticed, is simply fueled by this kind of point. And making tenants serve over and over again in the real world is a significant prejudice to tenants. So I don't accept my learned friend's argument that the consequences of invalidity are effectively negligible. It's expensive, demoralising and draining, and it allows the landlord to rack up additional costs on the second notice and the further counter notice. There's also the point about the consequences of invalidity for the landlord. All of my learned friend's points, I would respectfully submit, tend to create uncertainty for the important parties, namely the landlord. I think your lordships have this point, but the landlord is far better served by knowing that it's been served on him and possibly on co-landlords, and not having to be concerned whether the notice of withdrawal has been served on all of the qualifying tenants. Certainty for the landlord is far more important than the alleged need for certainty of the tenants as to whether or not the notice is continuing in force. And it did occur to me that you could have a scenario, what if the tenants decided to serve the notice of withdrawal before the landlord gave his counter notice? And then the landlord doesn't bother to serve a counter notice because the notice of claim has been withdrawn. Could the tenants then say, actually, we never served all of the qualifying tenants, so right to manage is acquired by default, because actually the notice of withdrawal was never valid. And the RTM company says, well, you never served a counter notice. On the learned friend's construction, it would be perfectly open to the RTM company and the qualifying tenants to engage in that manoeuvre. And it's not a fanciful suggestion, because of course there's likely to be, by definition, a significant identity between the RTM company and the qualifying tenants. If it's a valid claim, then by definition half of those qualifying tenants minimum have to be members of the RTM company. And that's another, in my submission, significant pointer towards the conclusion which the tribunals below reached, namely that service on the qualifying tenants is not essential to the validity of the notice of withdrawal, and the notice of withdrawal was effective when it was served on the landlord parties in this case. And if it was effective on that date, then it was given before the second claim notice. Second claim notice is valid, and the tribunals below came to the correct conclusion that RTM was acquired. I think that there's only one, subject to anything Malone Jr. may wish to point out that I've omitted to deal with. There's only one other elim factor which I haven't dealt with, which is this point about the risk of non-receipt and deemed service. It depends what you mean by the risk of non-receipt. If the risk of non-receipt is said to mean the risk that a notice is given according to the law but doesn't actually reach the recipient, then I accept that risk falls on the qualifying tenants of flats. But if the risk of non-receipt actually refers to the risk that the notice is not actually given to a qualifying tenant at all, then actually that risk, if my learned friend is right, starts to fall on the landlords as much as anyone else, because they are being told on the face of the notice given to them that the claim is withdrawn, but actually behind the curtain it's not withdrawn because it wasn't given to the qualifying tenant. So in that sense, the risk of non-receipt actually rebounds on the landlord parties, and that is, I submit, the wrong construction and the wrong answer. So for those reasons, which are, I submit, effectively the reasons elaborated perhaps a little by my submissions, but these are the reasons that the Upper Tribunal rightly came to. If one looks at the Upper Tribunal's decision itself, at page 109, then I've dealt with paragraph 53 and what the Upper Tribunal meant by paragraph 53. Paragraph 54, the Upper Tribunal then poses the right question. What is the consequence of omitting to serve a category of person? 55 through to 57, my learned friend accepts, subject to his prior point, that if he's wrong about that, he accepts that the Upper Tribunal looked at the right authority and applied the right principles. Paragraph 58 hasn't appeared in oral submissions. The Upper Tribunal was right when they say that the word must effectively doesn't mean a great deal in context, because what other word is going to be used? And you can get that.
That's the Osman and Nat.
It's Osman and Nat at paragraph 39, repeated in Canary Gateway at paragraph 82. So paragraph 58 is right in law. Paragraph 59, I submit, is also entirely right. The Upper Tribunal said main practical purpose. They weren't excluding any relevance at all to giving a notice for information to the qualifying tenants, but the Upper Tribunal is clearly right about the main practical purpose of the notice, which is all to do with alerting the landlord, who does suffer potentially consequences. He loses his right to claim costs from the tenant for dealing with the claim. He knows that he may be in receipt of a further claim notice, and that he knows that the further claim notice will be valid because the first one has been withdrawn. So that is, paragraph 59 is clearly right. And paragraph 60, the Upper Tribunal accepts if the appellant hadn't been served, then that wouldn't have been effective. And then at paragraph 61, by contrast, the Upper Tribunal was right in saying that, by contrast, service on the qualifying tenants doesn't have any of those purposes. It's just information. It does not have any effect upon the decisions they must make or actions they must take. Well, that's right, because there's nothing they can do. It's accepted. It's important for them to know that the notice has been withdrawn and they're entitled to have it sent to them, but the consequence is not that withdrawal is ineffective. Service one day late doesn't make any practical difference to anyone. So that's the thrust of the decision, and then there are supporting propositions at 62 and 63, which are right. It is at least potentially impossible to withdraw a claim notice, and that contrasts, as I've said, with giving a claim notice where you only need to give a copy. My learned friend didn't persist with the argument, well, it doesn't matter, you just have to wait for a deemed withdrawal. That can't be Parliament, the intention of Parliament. And then paragraph 63, the certainty point, which I've dealt with in my submission. Again, the Upper Tribunal absolutely right about that. The landlord is the person who really needs to know whether or not the notice has been withdrawn. And the landlord has no way of knowing whether it's been served on the tenants. The Upper Tribunal gives the point that it can't be right that the landlord could months later say, it wasn't served on all of the tenants. But equally, it can't be right that the tenants months later could say, we served you, the landlord, and you thought it was all withdrawn, but actually it wasn't. So there's no flaw at all in the essential reasoning of the Upper Tribunal. And also because this is a second appeal, technically, I suppose, we're dealing with an appeal from what the first tier tribunal said. And the first tier tribunal, although it's a shorter decision, came to the right answer for the right reasons. Page 138 of the bundle, paragraph 16, rather pithy. What matters is that his client, that is the landlord, received the notice of withdrawal. And the tribunal is satisfied that as of the 17th of June, the appellant had sufficiently conveyed the withdrawal to the first respondent, and the fact that the first respondent learnt of possible flaws in how others were notified considerably later is not relevant. That encapsulates the same point. It didn't matter that the notice of withdrawal was given to the qualifying tenants a day later. And as I've said, that the reason it ends up being given a day later is because, of course, the claim notice itself was just a copy. Learned friend, when he took you to the documents and he said, here's the letter serving the claim notice on the qualifying tenants, it wasn't. It was serving a copy of the claim notice on the qualifying tenants, which obviously can be done later. And it doesn't make any sense that you can't do that because you need to serve separately a notice of withdrawal directly on the qualifying tenants. It's an inconvenience point, but if my learned friend is right, you create a significant inconvenience in not being able to follow section 79(8) in respect of a subsequent notice of claim. Normally you just give a copy later, but you can't. Yes, my learned friend, as my learned junior, makes one point which I would add to the submissions I made about the scheme of the statute. When I pointed out that in section 86, A, B and C mirror section 79(6), there is also a mirror point with section 88 and costs, which is page 10 of tab 1 of the authorities bundle.
Section 88 which?
Section 88 subsection 1,
Yeah.
you get the same A, B, C. So under section 79(6), you give the claim notice to categories A, B, C. Section 88 makes the RTM company liable for the costs of categories A, B, C. The RTM company is not liable for the costs of qualifying tenants, and it doesn't have to give a copy of the claim notice to qualifying tenants. Therefore, why would it be essential to this procedure that you have to give a notice of withdrawal, D, to the qualifying tenants? Is there anything further with which I can assist?
No, thank you very much indeed, Mr. Rennie. Now, is there a reply? If there is, or you'd like to think about it, we'll give you the opportunity to do it over the adjournment. But if it's only a word or two, or you've made your mind up, we'll hear you now.
It may only be a word or two, but I would appreciate having the
By all
lunchtime
means.
if I may, to decide.
By all means. Very well. Well, we'll start again at 2 o'clock. Thank you.